Mr. Davis has really gone above and beyond. When it happened, I thought I was going to lose my mind during the case, and he's kept me calm. Having the knowledge that he has really helped a lot. And he knows what he's doing. He knows how the system works, and that's something that I entrust in my life with him. My daughter's my life. Everything within this case has not been easy, but he stepped in and he took charge of the case. And
Good morning. Good morning. This is Attorney Vince Davis, and these are my office hours. I want to give a shout out to Ashley. Ashley is from Ohio. My friend Ashley from Ohio. Today, we're going to be talking about a topic that's very common today. So I want to welcome you to my CPS office hours. I'm Attorney Vince Davis, and today we're tackling a CPS allegation that devastates a lot of families, and that is domestic violence. CPS uses domestic violence allegations to justify removal of your children, to deny you visitation, and even terminate your parental rights. But here's the truth. Being accused doesn't mean being guilty, and it definitely doesn't mean you should lose your children. Over the next 30 minutes, I'll walk you through how to fight and win against CPS allegations of domestic violence at every stage of the case. You'll leave today knowing what to say, what not to say, what to file, and when to call me. If you or someone you know is in the middle of a CPS domestic violence case, call my office right now. Don't wait. All right, part one. Understanding what CPS considers domestic violence. Of course, they consider physical violence, but they also consider domestic violence verbal abuse. They also consider domestic violence to be coercive control, witnessed or overheard by children, even not witnessed or overheard by children. They believe anytime the police are involved, even without arrest, there can be domestic violence. The key point and the key takeaway here is CPS doesn't need a conviction or a police arrest to file a petition against you for domestic violence. In California, the legal basis for doing that is California Welfare and Institutions Code, Section 300B, C, and maybe sometimes A. All right, that's the legal basis. Part two, what to do immediately after an allegation of domestic violence. First and foremost, do not, I repeat, do not discuss the incident with CPS. Say you want to speak through your attorney. Do not sign a voluntary safety plan without legal advice. You want to request from the police all reports and all CPS records. Not that you'll get them, but at least request them. Start securing character witness letters and start getting counseling referrals and maybe even start your counseling in domestic violence. It is not an admission of guilt if you start domestic violence counseling. If your children are removed because of these allegations, call me immediately. Time matters. Part three, strategy at the detention hearing. Prepare a declaration denying the violence or explaining the violence in the context through your attorney. You need to present evidence of your counseling enrollment, restraining order compliance, your clean police records, request immediate visitation with the children, propose relatives and family friends that the children can be placed with, propose a parenting schedule and monitored visitation if needed. On a recent case in Los Angeles County, necessarily wasn't a domestic violence case, but 81 relatives and friends of the family showed up to the court hearing. The judge was made aware of this by the bailiffs. The judge, to his credit, only allowed 13 people in the courtroom of that 81 because there was no more room. And the social workers didn't even want to release the children to any of those present, but the judge ended up releasing the children to my client, the mother, with one of the relatives living, actually two of the relatives living with the mother. The judge was able to meet those and see those people in the courtroom, and I think he even asked questions of those relatives in the courtroom. So it does help to have community and family support at the initial hearing. Propose a parenting schedule and monitored visitation schedule if it is needed. The key move is file a reasonable alternative parenting plan to the court. Part 4. Jurisdiction hearing defense. Challenge CPS's allegations line by line. Consider filing a trial brief with your attorney with exhibits and witness declarations. Make sure you bring those witnesses or make them available to be cross-examined by the social worker's attorneys. Consider using police reports, the 911 transcripts, and video, if any, to clarify the narrative. These days, a lot of people have video, the Ring cameras and such at their home. So if you have that, consider looking at that, giving those videos to your attorney. For cross-examination, always cross-examine the CPS worker. They use a lot of hearsay. They use a lot of multiple hearsay. And sometimes there's more than one CPS worker. There is the emergency worker who wrote the detention report. There is the dependency investigator who wrote the jurisdiction and disposition report. And then there's the social worker who provides services. And that person should be subpoenaed and cross-examined. I find a lot of times the services worker has a different opinion than the dependency investigator. The services worker sometimes has more contact with the family and may have a more positive view of the family. So you might want to consider having that person come to testify. Your goal at the jurisdictional hearing is to disprove or weaken the claim that the CPS social worker is making, and that the court finds insufficient evidence under Section 300 of the Welfare and Institutions Code. All right, Part 5, my favorite hearing, and the most important hearing of all CPS hearings, the disposition hearing and the strategy. If jurisdiction is found to be true, they call it finding it's sustained, focus on the disposition outcomes. Offer a detailed case plan with domestic violence classes, therapy, parenting. Request joint legal custody with monitored placement, not termination. And remember, at the disposition hearing, the social worker has to prove by clear and convincing evidence that you are a substantial danger and there are no less restrictive alternatives than placing your child out of your care. That's a very hard burden to prove, especially if you're in programs to alleviate the problem of the domestic violence, especially if you have relatives that move in the home with you to provide extra support and extra set of eyes for the social worker and the judge. It's supposed to be, foster care is supposed to be the last place the child should be placed for the next 6 months. The other thing that you should do is through your attorney and with your attorney's assistance, file your own proposed case plan. Sometimes the social worker files a case plan that has you doing things, 3 to 4 hours a day, 5 or 6 days a week. That's impossible sometimes when people have jobs and have other family obligations. So you and your attorney should file your own proposed case plan. The judge often orders the case plan that the social worker proposes because there has been no alternative submitted by you or your attorney. So think about filing your own proposed case plan and explain to the judge during the disposition hearing why your case plan would be sufficient under the circumstances. Part 6. How to use expert witnesses, a topic that's frequently overlooked. You want, in the domestic violence arena, hire a domestic violence therapist to testify about your anger management progress, your co-parenting ability, your changed behavior, which the judge is really going to be interested in. Use a psychological evaluation performed by a psychologist to determine insight and low risk of reoffense and low risk to the children. Your goal is to reframe the parent and yourself as safe, not perfect, but low risk and safe as far as the children are concerned. Part 7. Leveraging services to build your defense. You want to enroll early in the services. It's not an admission of guilt, but at the disposition hearing, it could be very effective. There are services such as the 52-week or the 26-week domestic violence program, even if it's not court-ordered yet. There's the individual therapy, and your therapist can come testify, as well as your domestic violence program instructor. Substance abuse counseling, if it was related to alcohol or drugs, and that person can come testify. Ask for attendance logs and progress reports. Here's a pro tip. Submit monthly progress summaries to your attorney for inclusion as exhibits to the judge. Part 8. Reunification at the review hearings. 6 and 12-month and sometimes 18-month reviews are critical. You need to file for increased visitation at each hearing and step-up plans if called for. Submit the declarations or compliance and expert opinions that we just talked about above. One of the keys is in these reports should be substantial compliance, child safety, parenting stability. Remind the preparers of these reports and progress letters that those types of words should be used because that is the nomenclature that the court is looking for. All right, part 9. Preparing for the 2-6 hearing if things go wrong and the child isn't returned. If reunification is denied, preserve rights through evidence of your bond with your child. That is the number one defense to a 2-6 hearing. You want to serve or prepare ongoing service participation. You want to come up with alternative plans like legal guardianship. And you want to appeal the ruling immediately if it's ruled against you. Remember, there are very short deadlines in juvenile dependency cases. If you are having problems developing a TPR defense, give me a call, 888-888-6582. Part 10, Civil Rights and Clearing Your Name. One of the last things that you should consider is consider a federal lawsuit if you believe that removal was illegal. Talk to an attorney. The grounds are no warrant, no emergency, fabricated allegations. So consult with an attorney. I'm involved in a civil rights case now where we had to file an 827 petition to get all of the court records to help prove our claims against the social workers. The juvenile court, which is in another county, ordered the release of the records. When we got the records, we noticed that certain documents were missing. And I knew the documents existed because I was involved in the case. But I couldn't use the documents in the lawsuit unless they were released pursuant to the court order. So we had to go back to court and get another order for the court, or to make the court, or to ask the court to make CPS give us those documents. The reason why CPS didn't want to give us those documents is because they would help prove our case of civil rights violations. So make sure that you request those documents. All right? Okay. So before we end the show, I'm going to go to the Q&A. Hopefully you have posted your questions in the comments. All right, from YouTube, Betty Joe, good morning. Good morning, Betty. Debbie Anderson from YouTube, good morning. Good morning. Cynthia Gabriella Livingstone, YouTube, we should call you ASAP. 888-888-6582. Cynthia from YouTube, I would have liked to call you before my child was taken. Yeah, a lot of people tell me that, Cynthia. Betty Joe, what happens if a mother files an order of protection against the father for the same allegations that she put against him for another restraining order in the state where the child was at, and now the mother doesn't live in that state? I think what you're asking, I think that would help you, Betty Joe, if you already had a restraining order and they're trying to charge you with failure to protect. But I'm not sure I'm reading your question correctly. Embria Darbo from Facebook, I only tell my good friends that they have the best service and fastest redemption. Just send message to the link below to get. Okay, I don't know what that is. Grace, if you're watching this, please delete that comment. It's somebody trying to sell something. Cynthia Gabrielle Livingston from YouTube, how can they take the poor children from a loving mother that has been a victim of domestic violence? That's a very good question, Cynthia, but they do. On top of the husband hitting her, and on top, take her children, how can they do something like that? Well, they justify it by using California law or using the law in your state, and they do it. Cynthia, and they try to cancel the mother's rights when she has been a victim. That is so horrible. I would agree. Cynthia, and what if Lord Jesus Christ wants to restore the family? Are they going to oppose God's restoring will? In most cases, yes, they do. They do fight against that. Dorothy Cook from Facebook. Good morning. This is great info to know and share with others. Thank you, sir. You're quite welcome. Facebook, coming clean. Leveraging service to build character. Submit monthly progress reports to the judge. Absolutely clean. Coming clean from Facebook. File for increased visitations if called for. Absolutely clean. Coming clean. Substantial compliance. Okay, coming clean. You probably know a lot about this. Cynthia, I know is not a mother's fault if she is a victim of domestic violence. CPS thinks otherwise, Cynthia. I think they should never take children from their families. I would agree. Lord Jesus Christ is the only one that can fix all family matters. I can tell you, Cynthia, that CPS has a different viewpoint. And unfortunately, they are the law, or they are the ones that enforce the law. Facebook, coming clean. Prepare for 2-6 hearing if things go wrong. Child not returned. Coming clean. 888-888-6582. That's my phone number. Coming clean. Consider federal lawsuit. No allegations. Oh, I see. Coming clean is taking notes of my presentation. Consider federal lawsuit. No grounds. No warrant. Fabricated. Cynthia says they should not oppose God. May only his will on families. He wants families together, not separated. Cynthia, I would agree, but that's the problem, is that there's a separation of church and state from the beginning of our country. And so they don't mix, religion and religious beliefs with the laws of child protection. Coming clean from Facebook, can a federal lawsuit be filed 7 years later after the closure of the CPS case? Coming clean, can it? Yes, but it's a very unlikely to be successful, probably because the statute of limitations has expired, at least in California. I don't know. I'd have to research or talk to an attorney in your state if you're not in California. Betty Jo from YouTube, the mother put a string order against the father in the state where the child is at, and then it was dropped, and then she put a new one on him in the state, I guess in a different state, she lives in now, and the father lives in the state where the child is now. Okay, there's Joe. I'm a little confused, and I'm a little confused on what the question is there, Betty Jo. All right. Margaret says, I did some research and found out that the foster parents are allowed to medicate without a prescription in order to wipe out the child's memory. Margaret, you would need to show me that law because I do not believe that is the law in California. But I'm always willing to learn. Margaret says, good morning, Mr. Davis. Good morning, Margaret. Brandy from Facebook. You are so right. I wish I could hire you. We had the worst MDT yesterday. I don't know what MDT is, Brandy. Brandy, but you can always call me, 888-888-6582. Betty Jo says, can they still keep the trial from both parents for visitations if there's an order against them? Betty Jo, in California, custody and visitation is always an issue. And it's my opinion, it could be, I believe that's the law. And it's my opinion, you can always challenge custody and visitation at every hearing. I hate to tell you this, but a lot of judges don't share that opinion and don't let me challenge custody and visitation at every hearing. But that doesn't stop me from trying, and it doesn't stop you and your attorney from filing a 388 petition. Okay? All right. I don't see any other questions here. And I did want to read one last thing. It's a quote that I found. Here it is. There may be times when we are powerless to prevent injustice, but there must never be a time when we fail to protest. If you're interested in protesting on my platform, please let us know. Email grace@vincentwdavis.com, and we'll invite you on as a guest to one of our shows on this platform. And you can protest what is happening to you. You can inform others what has been happening to you. All right, folks, I have to go to court this morning, so we will be seeing everybody tomorrow at 6:30 a.m. Pacific Standard Time on my office hours. Stay safe today, folks. Bye-bye.
I'm very, very pleased with Mr. Davis and so far the outcome of the case and how he's been there for me. He's been by my side. He's really gone above and beyond. He's an amazing, amazing attorney, an amazing person as well.